Okay, cool. All right, hello everybody. It's James Oliver Hacking III here with you to discuss the immigration news of the day with my good friend Mackenzie Simmons. Mackenzie, how you doing?
I'm good. How are you?
Good. My buddy Russ did a webinar today, and he didn't have a sidekick. I think it's good to have a sidekick because it keeps things fresh.
Yeah.
How's everybody doing out there? If you want to leave us a message, let us know in the chat where you're watching from. We'd love to see where people are all around the world. I'm not going to show my chat because some people ask us questions in private, so I'm going to rely on you, Mackenzie,
Okay.
to ask us the questions as we go. So no real agenda for today. It's sort of open line Tuesday. You get to ask whatever you want. We'll go for about an hour. I have to stop at 5 till because I have my last consult of the day at 5 o'clock. I've had a lot of consults today, some crazy consults today, including a very Jerry Springer type situation. But that case is not turning in. That consult is not turning into a case. So, all right, let's get to it. You got some questions for me? I think somebody emailed us a question or two too.
Yeah, actually, if you wanted to start off with that one, was that today?
It was. I probably sent it to you last night, I think.
Okay.
And you might have gotten it today.
Okay, well, I'm going to start with one in Webinar Jam while I find that
Yeah, sure,
one.
go for that. Yeah, it's fine.
Also, people on Facebook are saying that there's no sound.
Oh, no sound. Oh. Well, I don't know what we can do about that because of the stupid phone cord. All right, we'll have to shut down Facebook Live. Can you put a link to the webinar in there? Is it too late for people to switch over from Facebook?
I could do it. Okay, let me just give you a question so I have time.
Good. I'll shut this down. Let's see, I do that. Blue jeans. Stop sharing screen and hang up. I'm ready when you are.
All right. Will asks, during these COVID-19 times, in the process of preparing and submitting the I-130 for the spouse visa, as a citizen, what can be done to ensure I don't run into any problems with public charge? Here in the USA, everything is up in the air and people aren't working. Will this hurt the application process?
All right. So for everybody who did not file an application after, I think it's March 20th, anyone who filed an application after March 20th from here going forward, they're going to be subject to something called the public charge. So there has been a law on the books as part of the Immigration Nationality Act for a really long time that wants to make sure that American taxpayers don't have to support foreign nationals who come to the United States. And the way that they do that is with what's called the public charge analysis. So under President Trump, they have reworked the public charge rule. So historically, the way that a U.S. citizen would sponsor their spouse to come to the United States and to show that they can demonstrate for them, that they can provide for them financially, the U.S. citizen would file a form called an I-864. It's an affidavit of support. And that would involve the U.S. citizen, the petitioner, submitting 3 years worth of tax returns and all their W-2s and demonstrate that they make enough money to support the foreign national. And that was sort of the end of it. If the petitioner did not make enough money, then the U.S. citizen had to find a co-sponsor who would back up, and they would say, okay, if Mackenzie gets government benefits and she comes over from, where are your people from, Mackenzie? Oh, you're muted. It's all right.
I said China.
Oh, Mackenzie's people are from China. I didn't know that. So Mackenzie's coming over from China. They want to make sure she's not going to get government benefits. So they say, Chris, are you going to sponsor her? And Chris says, yeah. Chris gives the tax returns, the W-2s, and if Chris makes enough money, then Mackenzie can come. Well, in mid-March 2020, the Trump administration changed all that. You still have to do all those things that I just mentioned. There's still that part of the analysis. But then there's this other layer called the Petition for Self-Sufficiency if you're trying to adjust status. So that form is called the I-944. And in all honesty, it's a big, fat pain in the ass, and that is by design. So Donald Trump's little minions, especially Stephen Miller, think that they have figured out a way to stop or slow down legal immigration to the United States, and that's what they're after. They want to stop legal immigration. They think there's too many brown people and too many black people and too many non-white people in the United States. And so they think that if they attack people from poor countries, like from the continent of Africa or Asia, that that's going to stop immigration. And the way that they're doing that is they've devised this 6-part test called the public charge. The public charge rule itself ended up being somewhere between 850 and 900 pages long. The form, I think, is 17 pages, and it's more of a pain to fill out than the rest of all the other paperwork combined. So, for instance, in our office, when we handle a green card case, up until 2 weeks ago, or a month ago, we charged $3,500. But because of this new form that we have to fill out, it's an extra $1,500. So that's $5,000 just in legal fees. That's separate from the filing fees. But getting back to the question, that analysis all goes to whether the foreign national, whether Mackenzie, is going to become a public charge. And there's a lot of discretion in there. That the officer has some positive factors to look at and some negative factors to look at. And the thing is that they have a lot of discretion. And we never like USCIS officers to have discretion because there's not a lot of control or predictability as to what it is that they're going to decide. So at the end of the day, you're going to go to your green card interview and the officer is going to decide not only is the marriage valid and is the foreign national admissible to the United States. That's sort of what's generally covered by the I-130 and then the 485. But now they have another layer of scrutiny. So that's going to A, slow things down, and B, give them a lot more discretion. And discretion, I wish I could tell you the foreign word discretion in every language, but discretion means that the officer gets to decide. They can say yes, they can say no, and there's not real guidance on what the outer limits are, what cases have to be approved, what cases have to be denied. They just get to pick. And we never like them to be able to pick because that means they can deny cases that should be approved, and they should approve cases, and they can approve cases that should be denied. It happens all the time. So with the economy doing worse, with 22 million people unemployed, I think that that's going to affect the whole marriage process in a lot of ways. Number one, some people aren't going to be able to afford to pay a lawyer and they're going to do it themselves. Number two, some people aren't going to be able to afford to pay the filing fees and their spouses are going to get out of status. Number three, people might not make enough money and not be able to sign the affidavit of support by themselves anymore. There also might be less people who are able and willing to serve as the co-sponsor. So, and then lastly, unless you can show that the foreign national has an education, speaks English well, has money in the bank, has job skills, has health insurance. If you can't show those things, then you're probably going to have a hard time getting a green card for your spouse. So Andrew Bloomberg, one of the attorneys in our office, emailed me last week and said that he had just had a consult with someone who he was convinced could not pass the public charge, and he had that sad job of telling that formerly happy married couple, the couple, that they probably weren't going to be able to pull it off. So this is a huge deal even before the coronavirus, but with more people having a lot of economic insecurity, it's going to just take that to another level.
Mm-hmm. Okay. NT says, should my significant other, the foreign national, disclose everywhere he's lived, even if he lived somewhere illegally for work that was not in the U.S.?
Yes. Yeah, we get that question sometimes. We had someone once who was from Africa but had worked illegally in Italy. It's much more important to be honest about that. Working illegally in a foreign country is not going to prevent you from coming to the United States, unless, I suppose, if you have a conviction. But obviously, you're only going to offer that if they ask. But generally, they're going to ask, "Where did you work?" and they're not, "Where did you live?" and maybe where did you work when you lived there, because they go over your employment history. But for the most part, I don't think they get too deep into whether or not you had permission to work or what your status was in other countries. They have a hard enough time keeping track of U.S. immigration laws, much less the immigration laws of every single country where people might be working in a third country situation.
Okay. JJ says, I have a pending I-751 since 2017. I got an RFE and responded, but still haven't interviewed. We got the last notice in 2018 saying the case was transferred to the local field office and nothing since then. What can they do?
Yeah, so for those of you who don't know, if you marry a U.S. citizen and you get a green card and the marriage is less than 2 years, at the end of those 2 years, in the last 3 months before the 2-year anniversary of your green card, you're going to have to file an I-751, which is a petition to remove conditions. So when you first get married, they want to make sure that you're not engaged in immigration fraud, marital fraud. So they've come up with this 2-year plan where you get this 2-year green card. And for this person asking the question, they filed for the 751 a long time ago, and it's been pending. And the fact that they've been told that it was sent to the field office tells me they really suspect some kind of marriage fraud or some kind of fraud. And so I think the case is going to be stuck unless and until you sue them. So if you file a lawsuit in federal court, what'll probably happen is they'll come and knock on your door in a couple of weeks, early in the morning, to make sure that you're there. And then after that, the case should start moving again. They might call you in for another interview. A lot of times on 751s, we don't get interviews. Sometimes we do, sometimes we don't. So if the marriage is rock solid and you're not worried about that, then you might think about suing them. If not, then you might want to talk to us about that too, because if the marriage is shaky, or if there's reason to be concerned, or if there's what USCIS would view as indicia of fraud, living apart, big age gaps, not a lot of original marital evidence, there's lots of reasons why a 751 can go off the rails, but waiting 3 years for a 751 to be approved is a really long time. And you should probably think about suing for that one.
Okay. Pa says, I recently got my I-485 denied because of misrepresentation that I made in my visa application. I stated I was married and submitted a fake marriage certificate. Now that I have to refile, I want to come clean and tell them I lied, but I was advised to just get a fake divorce certificate from my home country, which will be easier. What do I do?
Well, if my dad were here, he would say, Jimmy, just because it's easier doesn't mean it's better. We already tried the easier route, right? So we're done filing false documents from the home country. They already figured that out once. So I assume that the I-130, so let's talk about what's going on in this scenario. So foreign national comes to the United States on a visit visa, lies about being married. So in our office, we've seen this happen probably 25 times, 30 times. So that means if we've seen it 25 or 30 times, USCIS and the State Department has seen that hundreds and thousands of times. So when you, it's interesting that the 45 was denied. They might have invited her to file a waiver. You can get a waiver for misrepresentation, but you're going to have to show hardship on the part of the U.S. citizen. So I would say that you should stop what you're doing and get a lawyer to help you. You're not going to be able to pull off keeping your status. If your 45 has been denied, you need to start calling the 1-800 number to make sure that you're not in removal, because they can send you to removal and you might not get the notice right away. So whereas 1-800-898-7180, you can punch in your alien number, and you should call that number once a week in the time where you're trying to file a new application. But there's a ton of work to be done, and they could put you in removal at any time. So the situation is sort of urgent. There is a path for you to stay, but it takes a lot of work and a lot of time. And you got to be careful even how you answer questions in the new 485 based on the prior misrepresentation. And of course, now you're going to have to deal with that same public charge rule that you didn't have to before. So it's a big old mess. Lots of issues. When I was in law school, they'd give us a fact pattern. You have to find all the legal issues and spot them all, and then you'd have to figure out what the possible solutions are. And this case has lots of different things to work on and focus on.
Okay. Maria asks, if someone wins the green card lottery this year, can they still apply for it within the USA?
Yes, they can. So if you're in the United States, and so every year Congress sets aside $55,000 green cards for people from different countries, and that's the diversity visa lottery. So if you're from a underrepresented country, so they take the number of people in the United States from each country, and they figure out the top 20 countries that are most popular. If you're not from one of those countries, then you can apply for the diversity visa. And the way that it works is if you get selected, you can either process your case overseas at an embassy, or if you are in the United States, and if you are in status, you can process your diversity visa. So let's say that you're here from Iran, you're going to graduate school at the University of Illinois, and you are in valid F1 status. If you get selected in the diversity visa and you maintain that status up until the time that you adjust, you can apply for adjustment of status based on that diversity visa selection. Now, the tricky thing is that they've split up the world into sort of 4 quadrants, and there's caps on each quadrant. So, and those go by country. So the tricky thing about the diversity visa is it starts September 1st and it ends, it starts October 1st and it ends September 30th. So you have to get the whole process completed in 1 year. So right now we are in April, almost May. So right now people towards the end of the line should be coming current, and they need to work really hard and really fast and really well to make sure that they get their case completed by September 30th. Because if you don't, the fiscal year is over and you don't get the green card, and it's as if you were never selected. So I'm writing down, I need to do a video on this, video on adjustment for DV winners in the United States. But yeah, and you know, right now with President Trump's proclamation, diversity visa winners overseas can't get their visas for the next 60 days at least. So being in the United States is actually very lucky.
Okay. Omar says that he is a U.S. citizen and he was planning to go to Pakistan for meeting his fiancée in March. But due to COVID-19, that was canceled. He has not met her in the past 10 years, so is it possible to apply for her under fiancé visa without meeting her first?
No, you have to meet each other face to face in order to, you have to, part of the application and part of the requirements are you have to prove that you've been in each other's physical presence at some place in the globe in the last 2 years. Otherwise, it won't work.
Okay. Samihan has said.
Oh, there's our man, Samihan.
Yep.
Samihan, what's going on? He's like, we should figure out a way to get Samihan on audio wise, because he's on every episode. Samihan, how you doing? All right, let's go.
All right. He said, question 22 on the N400 asks, have you ever attempted to commit a crime or offense for which you were not arrested? You must disclose this information even if somebody told you not to. He wants to know, does this violate an immigrant's Fifth Amendment right to silence? What happens if you skip the question without giving a yes/no answer?
So luckily we know that Samihan is in law school, so he's asking lawyer questions, and he's probably taking criminal procedures, so he's wisely looking out for immigrants in the criminal context. And of course, we need to remember that immigration, even though it has so many punitive and punishing type aspects to it, it's ultimately a civil matter. So an immigrant certainly has the right to invoke the Fifth Amendment and not answer a particular question. The consequence of exercising that right, however, is that you're not going to get your green card or your citizenship. So the answer to that question is no. You can leave it blank, but your case will be denied. So then it's sort of like, well, why are you even going to apply? So I've had 1 or 2 interviews that I've actually stopped because I was afraid that my client was about to disclose something criminally related that maybe USCIS didn't know about. But you have to remember that with citizenship, you have to show 5 years of good moral character, and it's your burden to prove that. So sorry for my voice, and sorry if I'm a little out of it today. I'm fasting for Ramadan, so I'm a little bit out of it. It's sort of towards the end of the day. Maybe during Ramadan we should do these a little earlier, but we're okay. Anyway, you need to remember that you're asking for a benefit from the federal government, and it's your obligation to demonstrate by a preponderance of the evidence that you're entitled to the benefit sought. So if you refuse to answer questions either in written form or at the interview, you can do that, but you're probably not going to get the immigration benefit that you so desire.
Mm-hmm.
And I'm going to make a video about that because that's a good question. Can an immigrant plead the fifth? Now, I will say that one thing that happens a lot, especially with my Muslim clients, is the FBI likes to come visit and chat and just come over. In those situations, you really want to be careful about what you say because, of course, lying to a federal officer is a federal crime. So sometimes there's more important things than the immigration benefit. So there are plenty of times where immigrants and everybody should plead the Fifth Amendment, especially if you're being questioned by the police. Let me just use this as an opportunity to remind everybody that if you ever get into contact with law enforcement, if the FBI shows up at your house or if somebody wants to talk to you, here's what you say. I'll be happy to talk to you, but I'd like to have my lawyer there. Can you give me your phone number so I can call my lawyer? And if they keep asking you questions, say, respectfully, I don't want to talk to you without my lawyer, and then just be quiet. And that's the hardest part, is actually being quiet, right? So that's the immigrants have Fifth Amendment rights, but you have to be careful in how you exercise them, and you have to be careful in what you tell people. So as always, this is not legal advice, but if you find yourself in a situation like that, you're probably going to want to talk to either a criminal defense lawyer or an immigration lawyer or both.
Okay. Yasir says he had an I-130 approved, but the I-485 has been pending since May 2019.
Mm-hmm.
The interview was done 6 months ago. Can anything be done at the moment to move the case forward?
Yeah, so I had this exact consult today, very curious case where the I-130 for a fellow from Yemen has been approved, but the 45 has not. Usually that tells me there's some questions with the background check, with identity, they're wondering who the person really is, and or they're wondering whether the person is admissible to the United States. So the answer to that question is the only way you're going to get them to decide the 45 most likely is to sue them, and the lawsuits are still working. So the courts are still open. The clerks are still issuing the summonses, which are what we need to get the cases moving. Immigration says that they're going to reopen June 4th, so we're back in business as far as filing lawsuits and trying to move cases along. So if your I-130 and your 45 get separated from each other, that's probably a sign that something's wrong with that. What that means is they believe the marriage, but they also think there's a problem with the foreign national and their ability to adjust status. That is, whether they are admissible into the United States. So for a case pending that long, you're probably going to end up having to sue over it.
Okay. Maureen asks, have you had cases of non-STEM students with F1 visas who got H-1B sponsorships or other type of visa sponsorships? What are my options as a non-STEM student?
Okay, so in that scenario, so just so everybody knows, just to give everyone a little grounding in all this. So when you come to the United States as an international student and you're on your F1 visa, at the end of your studies, you can participate in something called the optional practical training, which is OPT. And if you have a degree that is not a STEM degree, so STEM degrees are science, technology, engineering, and math. That means you're going to get 1 year of OPT, which means that if you graduate in May, you're going to be able to work for 1 year for an employer, or you can start your own business, but most people go to work for an employer. And the reason that's so important is because the following April, the employer can file an H-1B application for you. They can't file it for you before you graduate. They can only file it for you after you've graduated, because otherwise they can't rely on the education as part of the reason for hiring the person. So what that means is that you really only have one chance to go through that H-1B lottery. It's also why it's important to graduate in May and not in December, because if you graduate in December, your OPT is probably going to start at the end of January, which means you're only going to have one chance at getting the H-1B application on file. And my point is that if you graduate in May and start your OPT in June, then June, July, August, September, October, November, December, January, February, the company can see how you perform for 9 months. And so that's like a 9-month job interview. And in answer to the question, every year we have students and employers who contact us, and we don't do a ton of H-1Bs. We do like 15 a year, but every year 1 or 2 of those are people with bachelor's degrees who have made such an impression and were such rock stars during OPT that they were able to find an employer who was willing to sponsor them for an H-1B. And so the answer to the question is yes, it'll work even if you're not in a STEM field.
Mm-hmm. Okay. Munawar says, I got my 2-year green card in 2017 through my marriage. They were living together, but after 1 year of marriage, we separated due to some problems and we got divorced. I applied for the I-751 last year to remove the conditions on my residence, and I'm still waiting for the interview to come. My question is, what are the chances of getting a 10-year green card, and what do I have to give to USCIS to prove that I entered the marriage in good faith?
All right. So we already talked about how the 751 works. Some people, when a marriage goes bad, apply for the 751 on their own. They don't file it jointly with their spouse. Obviously, these cases are harder to win than than cases where the couple remains married. And there's lots of different reasons for that. Number one is sometimes the U.S. citizen tries to stop the foreign national from being able to get a green card. They might write letters to USCIS, say mean things. They might not share any of the couple's marriage evidence. And it's tricky. These cases are hard to win. In fact, in our office, we treat these cases almost like a deportation case. And what do I mean by that? Well, we spend a lot of energy interviewing the foreign national. So what we do is we get their whole life story from when they first came to the United States to how they met their spouse, to how great the marriage was, to how much they were in love, and then to how things started to go bad, and then an explanation as to why things didn't work out. Then we go out and we find all the evidence that we can to support that, right? So my wife handles a lot of these cases. She likes them. They're very fact intensive and they take a lot of work. So I know that she's done things like track down neighbors to verify that the couple seemed happily married, that she gets affidavits from them. You're always going to want to get all the marital evidence from the initial submission, but then you're also going to want to submit whatever updated marital evidence you can get from after the time that the initial 2-year green card was received. It's really a lot of work. There doesn't necessarily have to be an interview. We've done about 20 of these, and I think we've only had an interview on 2 of them. These we call them solo 751s or self-petition 751s. You can get them approved, but you've got to, I mean, these things look like this when we send them in. It's got a ton of statements. Sometimes we even ask the U.S. citizen. So the question I always ask people is, okay, so let's say Frank is here in the office and Frank is under this kind of a scenario. I say, Frank, will your spouse be a red light, a yellow light, or a green light? Red light is they're going to stop us. They're going to do everything they can to try to get us deported, get Frank deported. Yellow light is they don't care. They don't want to get involved. They don't want to be part of it. If you stay, you stay. If you go, you go. And green light is they'll help. So sometimes during the course of a divorce, a spouse might move from yellow to red or red to yellow or yellow to green, whatever. And our job is, if we can, once we have the whole story from the foreign national, we might go back to the U.S. citizen and say, hey, we're trying to keep Frank here in the United States. He seems like a pretty good guy. Would you be willing to give us a statement that says that Frank and you had a valid relationship, that things just didn't work out, and you wish they had worked out, but it was a marriage for love, not for a green card, and oh, by the way, you think he's a good person who should get to stay in the United States. If we can get them to say that, that's really going to go a long way towards helping someone get that 10-year green card.
Okay. Layla asks if this proclamation lasts longer than 60 days and a child of a lawful permanent resident turns 21 before the interview, is he still qualified for CSPA?
That is a great question. This is actually, when your parents are both immigration lawyers, these are the kinds of conversations you have around the dinner table. My son was asking us about the CSPA. So the Child Status Protection Act is a law that got passed, I think, around the early 1990s that allows USCIS or the State Department to freeze somebody's age. So there are a lot of benefits that occur that are available to the children of LPRs, lawful permanent residents, who are under 21 than those who are over. Or there's lots of scenarios where a U.S. citizen might sponsor his brother. In that case, can take like 14 years. And then once it gets to the embassy, one of the kids might turn over 21. Well, the Child Status Protection Act has this calculation where you can actually freeze somebody's age under 21. And so the question here, and usually that involves an analysis of were the delays at USCIS in the processing of the I-130, the petition. You subtract the amount of time the case was pending with USCIS. So if people are affected by this 60-day proclamation, will the Child Status Protection Act cover this time period too? My answer to that is I don't know. Obviously, nobody's gotten along that far yet. There's no rule on that yet, but I certainly think we'd have an argument that it should apply here, but I think that it probably doesn't. I think that at the end of the day, the CSPA is very specific in how you do the calculation, and I don't think it would allow for granting of extra time because of Trump's BS shenanigans stopping this ban. But when we were talking about this at dinner last night, that is an argument that we can make about CSPA and kids and this delay. So not much of an answer, but oftentimes a lawyer's best answer is it depends. And so that's my answer, and that's what I'm gonna stick with. Hey, there's somebody on here, I see him right here. He's been emailing me a lot the last couple of days. I've been trying to sue Donald Trump, so I've been a little distracted. I haven't been able to email my list like I usually can, or my people when they email me. So I'm gonna look at this one right now because I know he's emailed me about this 4 times. I'm a green card holder and my wife is in India right now. What will happen to applications which are under review at NBC when they are given to U.S. consulate under the ban? Will the complete application be denied, or will it be stuck on interview scheduled until ban is lifted? So I made a video about this morning because that's a real question for people. And unfortunately, I do have the answer to this, and I can tell. And when I say unfortunately, I mean that I know the answer to this because we've seen prior bans. So what do we go on? We go on the experience that we've had dealing with the former Muslim bans from the Muslim countries that Trump banned immigrant visas for all kinds of people from those countries, right? So in those cases, when Trump bans a new class of immigrants here, the spouses of green card holders, it still means that USCIS will receive the I-130. It still means that USCIS will process the I-130. It still means that USCIS will approve the I-130. It still means that USCIS will send the approved I-130 to the National Visa Center. And it still means that the National Visa Center will process it. It even still means that the National Visa Center will approve it and send it to the embassy overseas. And so far, based on the prior bans, the embassies will continue to process it. But then when the time comes for you to actually have your interview, you'll go there and you'll get a refusal. It'll be a temporary refusal. It's not a denial. So, I mean, if things are treated like they are now, you won't have to start all over. You'll just have to wait until the ban is lifted. That's sort of what's going on. So in theory, let's say this ban goes into effect, and let's say that the president does not get reelected, but when he leaves office, the Muslim ban and this new immigration ban are both still in effect. The new president can undo those with the swipe of a pen, and I would imagine the new president would do that on the first day in office. This is assuming that Trump is going to lose. And of course, you can never underestimate the American voter, and it's entirely possible that he might get reelected and he might come up with more bans. I sure as hell hope not, because I'll be really stressed out. But at the end of the day, if a new president were to do away with those bans, then I believe those cases would turn back on and the embassies would start processing them again, probably based on the oldest one. So hopefully my friend who has asked to remain private with those questions that I've answered, and I'm sorry for not emailing you sooner.
If the foreign spouse will be grilled on everything the American spouse has done, will the American also be grilled on everything the foreign spouse has done?
I'm assuming that this is in a green card context, because typically the U.S. citizen is not at the interview overseas. The way that separation interviews, Stokes interviews, they're called, when the couple is separated, anything's fair game. If USCIS thinks they know things about the foreign national, they might very well ask the U.S. citizen about that. If they think that the U.S. citizen has some shaky things in their past, they might ask the foreign national about that. So pretty much in a marriage-based case, anything is fair game, and it could go either way.
Okay. Khalifa says, if I worked without authorization before the adjudication of my asylum, which was eventually granted, would I be disqualified for this adjustment of status?
No. No,
Okay.
that would be forgiven.
Okay. Czar asks, if the proclamation was blocked in federal courts, but we all know that the Supreme Court will probably support the proclamation, and probably of blocking federal courts, legal challenge is high. How long does it take approximately until it comes for the judgment of Supreme Court?
That's a great question. So, and you're asking the right man, because I just researched this all the other day. It looks like it takes a federal court, about a district court, about 5 weeks to rule on a temporary restraining order on a case in front of it. So, and we know this from prior Trump executive orders. So Trump has actually had a lot of executive orders related to immigration, not just the Muslim ban. So, you know, with the first Muslim ban, you'll recall that he issued that ban, I think it was the second Friday after he took office. It might have been the first Friday after he took office, but I think it was the second. And remember, all hell broke loose and people at the airports were going crazy. They weren't even letting in lawful permanent residents. Trump hadn't distributed it to Customs and Border Patrol. There was no real rule or rulemaking or any way to, no directions on how to implement it. So that one got challenged in court, and that got held up. And the federal court issued an order stopping the enforcement of that travel ban. So I think Trump started to appeal that, but then he said, no, forget that. We'll just issue a second proclamation. So they issued the second proclamation. It was still problematic. It still wasn't very well written. So it got stopped by the courts once again. And then again, Trump chose not to appeal, but rather issued the third ban. And this one was a little more detailed. It had a little more guidance. It ultimately ended up being 14 pages. And that's the one that went to the Supreme Court. And it's interesting that that one went all the way to the Supreme Court on appeal. So that got all done in about 9 months, I think, for travel ban number 3. Now, Trump has had some other executive orders that have gone a little more quickly. So I anticipate, of course, if a judge doesn't issue the restraining order, then the order remains in effect. If a judge issues a restraining order, the government will either appeal right away, or they'll issue a new presidential proclamation that sort of addresses some of the issues for why the federal judge stayed it. So, but let's assume that it appeals. It's probably going to be, if a lawsuit was filed today, it's probably going to be resolved at the district court level in about 5 or 6 weeks. And then the government's going to appeal, and that's going to take probably another 5 or 6 weeks. And then the Supreme Court could take it anywhere from a few days after that or months after that. And so I think that's sort of what the the people that are challenging the ban are looking at is, well, can we get this tied up in the courts until the election is resolved and we know who's going to be the next president? And so, and of course, the president knows this, and that's why he's doing it, because every time he's on the news for stopping immigrants from coming to the United States, that makes his base really happy. So that's a long-winded answer to say that I think it'll probably take at least 6 months to work through to the Supreme Court.
Okay. Sashank asks, I'm a green card holder and my wife is in India right now. What will happen to applications that are under review at the National Visa Center when they are given to the consulate under this ban? Will the complete application be denied, or will it be stuck on interview scheduled until ban is lifted?
Yeah, I answered that one a little while ago.
Oh, sorry.
It's okay. I saw one too that was asking, like, when do I sue? Somebody said their 45 was pending for more than a year.
Mm-hmm.
I think I always look at, when did you file the case? And I accidentally filed a case that had only been pending 10 months last year, and they filed a motion to dismiss saying that it wasn't too much of a delay. But I think anything over a year and a half is certainly fair game for a lawsuit.
Erman says that he's been seeing a lot of posts on Facebook that people are asking what happens if they use their own country passport after asylum.
Yeah, so when you ask for asylum in the United States, you're telling the federal government that it's unsafe for you to go back to your home country, that you're going to be persecuted. And we then see people do dumb stuff after that. So they get asylum, and even before they get their green card, they go back to the home country. That's a really dumb, bad idea, because they could very well not only deny your future green card application when you tell them where you visited, which is part of your travel history, and they might also just revoke your asylum. So I never would have thought that would happen, but it's starting to happen. So it can even happen if you get when you're applying for your citizenship, if they figure out you've been back to the home country, or use the passport of your home country. I think visiting the home country is more of a crime or problem than actually using the passport. But doing anything to avail yourself of the government of your homeland after you've been given asylum, I think, is a really bad idea. So I would not do that.
Mm-hmm. Okay. Andy says, oh wait, did I already do this? Filing an appeal for an I-130 denial? I don't think so. Okay. No. Andy says he's filing an appeal for an I-130 denial. Should I say yes or no to the following question? Do you desire an oral argument with the Board of Immigration Appeals? Also, should a request be placed for the appeal to be reviewed by a 3-member panel instead of a 1-member panel?
These are all the wrong questions. If your I-130 is denied, you should not file a motion to reopen or reconsider. You should file a new I-130. Mm-hmm. You're never ever going to get the Board of Immigration or the Administrative Appeals Office to reverse an I-130 denial. You have to start over and file a stronger application and win it at USCIS. There's lots of reasons for that, but some are that you're not going. The only reason I could see trying to appeal an I-130 that was denied is if you think that you're not going to be able to beat public charge on the new one, and you'd be applying under the I-130 was under the old rule. But even then, I bet you that 95% or more of appeals to the Administrative Appeals Office get denied. So I think you're totally wasting your time. And the other thing is, we don't help people fill out forms. I can't tell you how to answer questions, but I can tell you that filing that form is a waste of time and money, and it's not going to move you forward at all.
Mm-hmm. Okay. Chucky wants to know, how long should a background check usually take after an I-130 interview? The wait seems like forever.
Say that again?
How long should a USCIS background check take after an I-130 interview?
If USCIS is telling you that your case is under a background check after an interview, they're lying to you. The background check is done before the interview. So that's just some spin on them sitting on your case, and you probably need to sue them.
Okay. Aaliyah asks if there's a possibility for immigrants who are outside of the U.S. to hire a lawyer that is in the U.S. to help them.
Why, yes, there is. Yeah, we handle cases all over. So we do Skype consults for people overseas. We're helping a couple of DV winners from Russia and Belarus. So yeah, we can handle cases. You can definitely get, I mean, it depends on what it is. Like, we don't get involved in visit visas or F1s or most non-immigrant visas. We do some E2 non-immigrant visas, but for the most part, we work with a lot of people overseas, and obviously a big part of our practice is the consular processing stuff. So in those situations, we have one client in the United States and one client overseas.
Okay.
I see one real quick.
No,
Can I do
go
one
ahead.
real quick?
Yeah.
Tosin wants to know, I'd like to know if my tax 1040 filing married separate can hurt my green card processing. Tosin, I don't think that's something you need to worry about, especially if there's economic reasons why you can show that that's what you're doing. I think that if you have a ton of marital evidence, then this isn't really going to affect it. If you don't have a lot of marital evidence, it certainly doesn't help. So standing alone by itself, I don't think it makes that big of a deal. But if it's a problematic case and you're filing separately and you don't have a good reason for it, then you're probably going to need to rethink that one.
Okay. Noha asks, my husband and I came to the U.S. after a successful NIW application. He was the primary applicant, and the two of us, plus our only daughter, got our green cards. He continues to work overseas, but he's in the U.S. for 40 to 45 days out of the year. My daughter and I live in the U.S. for 9 months out of the year. If I, the spouse, attempt to file for citizenship, can they refuse on the basis of my husband's intent?
I think the question is a very interesting question, but I think it's phrased slightly differently, and I would encourage Noah to think of things a little bit differently. If her spouse, who was the recipient of the NIW green card, that's national interest waiver for those of you who don't know. So this is where people are doing work in the national interest. They don't need an employer to sponsor them for a green card, but they're doing work that's important, and that's the basis of the green card. So Noah asked a very good question. She's spending 9 months out of the year in the United States, so she's fulfilling that requirement towards citizenship that she spend at least half the time in the United States. She's spending 3/4 of her time in the United States. So she's good to go to apply for citizenship. And then she asked, well, will they deny me because my husband isn't here very often? The answer to that question is no. In and of itself, the fact that the husband lives overseas more time out of the year is not the problem. The problem is that by filing for citizenship at this time, she could trigger them looking at the husband's green card case a little bit more. So in the old days, the purposes of a naturalization interview were to see if the person gets their citizenship. These days, the purpose of a naturalization interview is to see if they can take away a green card and, oh, by the way, maybe give you your citizenship. So in theory, they could say, hey, he's coming back every 6 months. He only stays for a month, and then he goes back overseas. We gave him this green card, which everybody knows is lawful permanent resident status. They might just question, not that they would have a totally legal basis to do it, but I think it could make things problematic for him entering or leaving if he's still going to be in these long time periods where he's not here. So on the one hand, I would really, really encourage them to get him over here and have him stay here doing his work in the national interest, because I don't want them to lose the green card. At the very least, I would wait until see what happens with the election and see if there's a new, I mean, they're just looking for people to mess with immigration wise. And I would hate for Noha to hand them on a silver platter a great thing to start beating people up with. And that would be the fact that the husband stays out of the United States so much.
Mm-hmm. Okay. So we got 9 minutes left, and Aaliyah asks if it's possible to have legal help with striking down the Trump's executive order.
Yeah, so I know that there's a lot of lawyers that are looking at it. And the question goes on about whether they should file suits in multiple places. I think so, but we'll just have to wait and see. I don't know there's much that people can do. It's a really big project. So I took a look at this over the weekend. I spent some time with it. It's a really big project to try to strike down an executive order from the president, even one that so clearly is contrary to federal law. So I think right now you can just sit tight and and root for the good guys and see what happens. Mackenzie, I do got to stop at 55, so we probably got time for one more minute or one more question. One or two.
What are questions that USCIS usually asks to I-751 applicants if the applicant is filing by themselves?
Yeah, so in those scenarios, typically what happens is the whole thing goes to the validity of the original marriage. Those interviews are generally pretty short. They just want to know, and like I said, we've done 3 or 4 of those where there've been actual interviews, and they've all been very short. They just want to see updated documents. They want to make sure that you're a good person and that you weren't pulling their chain, and they might just ask you some details of the marriage. Every now and then they go talk to the foreign national before the interview, but I don't think there's much you need to worry about as long as you're telling the truth.
Mm-hmm. Okay. Last question. Tosis wants to know, how do you work with clients outside of your state?
Yeah, so the great thing is that immigration is federal, so we can practice in all 50 states. So we help people all over the country. There's some things where it makes a whole lot of sense economically for us to get involved, because I can handle an overseas case for a spouse here in St. Louis just as easily as I can for somebody in Maryland. There's some cases where people might not want to pay for us to come to the interview, but plenty of people do. So we do handle cases. That Baltimore field office, we've actually handled a lot. I've sued them a lot, and we've had a lot of cases in Maryland. And in fact, we just had our very first case from Alaska this year. So we have had Hawaii too. So we might have all 50 states. I should probably sit down and map it all out. But yeah, we can, with technology these days, with things like Skype or Federal Express or email, all those things, it definitely works.
Okay. How can people contact you if they want to get a hold of you?
Thanks. So I'll give you the spiel I give at the end of every video. So thank you all for joining with us. I hope, Munawar, thanks so much for the kind wishes. Everybody, we're glad you were able to join us. Thank you. We'll do this again, I think in 2 weeks, right, Mackenzie?
Yes.
Yep. And so in the meantime, if you need to get a hold of us, you can call us. The phone number is 314-961-8200. There's my friend Zahar. 314-961-8200. Samihan, love to see you there, kid. Our email address is info@hackinglawpractice.com, info@hackinglawpractice.com. We have our Facebook group, which we were trying to push this in there. Hopefully, I don't know if Demio lets us push into Facebook. Does it, Mackenzie? I don't know. Hopefully it does.
I'm not sure, but I'll look into it.
And then, so that's called Immigrant Home. You can post your questions in there. We try to answer them when we can. We can't give out legal advice on there, but we can talk about topics of the day. And then, of course, we have the YouTube channel. We got a ton of subscriptions this month. We had 1,700 people subscribe in the last month, which is insane. My kids love it. My kids think I'm a YouTube star, and then they like to make fun of the old fat man with his YouTube channel. But I've got them because I've got many more viewers and subscribers than they do. So that's good stuff. Mackenzie, thanks as always for your help, and we'll see everybody next time, okay?
All right.
Thanks, guys. Stay safe. Thanks, Omar. Assalamu alaikum. Ramadan Mubarak. Bye, guys.